You are not paranoid. You really did just watch the Justice Department admit to what can only be described as a systemic failure of transparency. For years, the public was promised that the Epstein Files Transparency Act would finally dismantle the wall of secrecy protecting the world's most powerful individuals. But tonight, the architects of that very system have made an admission that should chill anyone who believes in the rule of law. They are still hiding 99% of the truth. This is not a conspiracy theory. It is a mathematical fact buried in a 5-page letter from the Southern District of New York. As we pull back the curtain on this admission, we have to ask, is this a matter of limited resources, or is it a calculated effort to ensure the most damaging secrets stay buried forever? The headline that has sent shockwaves through the legal community is simple but devastating. The Department of Justice has released less than 1% of what they have identified as the Epstein files. To put this into perspective, let's look at the hard data provided by U.S. Attorney Jay Clayton. To date, the department has posted approximately 12,285 documents, comprising approximately 575 pages, to their public library. While that might sound like a significant amount of information, it is a mere drop in the ocean. The DOJ admitted in the same court filing that there are more than 2 million documents potentially responsive to the Act that remain in various phases of review. This is not just a delay, it is an information gap so wide that it threatens the very concept of government accountability. The immediate question is, why? Why, after bipartisan support for transparency, is the process moving at a glacial pace? Legal experts point out that part of the blame lies with Congress, which created the Epstein Files Transparency Act with significant loopholes. These loopholes allow the DOJ to redact information based on existing criminal investigations or national security concerns. Crucially, there is no enforcement mechanism in the law to compel the DOJ to speed up the process. This creates a situation where the department can slow-walk the release of files indefinitely, classifying documents in their mind to avoid public scrutiny. From a neutral standpoint, the Justice Department argues that this work requires substantial resources to protect sensitive victim information. They claim to have deployed over 400 lawyers across the department, including 125 from the Southern District of New York and 100 specially trained FBI document analysts. However, skeptics note a troubling hierarchy of redactions. While the department is quick to pull down accidental releases involving certain political figures, information belonging to victims has been improperly posted multiple times. Furthermore, the review team is led by political appointees rather than the career prosecutors who actually handled the Epstein and Maxwell cases. This raises a critical question. Is the primary goal to protect the victims, or is it to manage the political fallout for the elite? The dog that didn't bark in this 5-page letter is perhaps more revealing than the million-page backlog itself. When you look at the primary signature line of this document, you see 3 names: Jay Clayton, Pam Bondi, and Todd Blanche. These are not just any lawyers. They are high-level political figures appointed by the administration to lead this specific investigation. What is conspicuously missing is the name of a single assistant U.S. attorney who actually prosecuted Jeffrey Epstein or Ghislaine Maxwell. This absence is a critical detail for anyone trying to understand the internal dynamics of the Justice Department. Career prosecutors, the people who have spent years living with the evidence, interviewing witnesses, and building the case, are notably absent from the top-level disclosure efforts. Instead, the signatures belong to people chosen for their loyalty and their alignment with the political executive. It raises a profound question about the review process. Is the filtering of these 2 million documents being guided by legal precedent or by political strategy? The Justice Department defends this structure by pointing to the sheer scale of the task. They argue that a team of 400 lawyers is necessary to handle the volume and ensure that sensitive victim information is not wrongly disseminated. However, critics like Dave Ehrenberg point out that the administration specifically avoided involving career prosecutors who served under previous administrations. For example, Maureen Comey, who successfully prosecuted Ghislaine Maxwell, was notably unavailable for this process. Instead, the number 2 person at the DOJ, Todd Blanche, who was once a defense lawyer, was chosen for tasks as sensitive as interviewing Maxwell herself. This shift from career experts to political supervisors creates a bottleneck of influence. While the hundreds of lawyers on the review team might be doing the heavy lifting of reading pages, the ultimate decision on what is redacted and what is released rests with the supervisors at the top. From a neutral standpoint, this could be seen as a necessary measure for executive oversight in a high-profile case. But from the perspective of transparency advocates, it looks like a system designed to ensure that the chips only fall where the administration wants them to. The concern is not just about who is in the room, but who has been pushed out. When career prosecutors are sidelined, the institutional memory of the case is lost. These were the people who knew which names appeared in which ledgers and which flight logs mattered most. By replacing them with political appointees, the department has essentially reset the clock on the investigation, allowing the review process to become a permanent shield against the full disclosure of the Epstein network. The dog that didn't bark in this 5-page letter is perhaps more revealing than the million-page backlog itself. When you look at the primary signature line of this document, you see 3 names: Jay Clayton, Pam Bondi, and Todd Blanche. These are not just any lawyers. They are high-level political figures appointed by the administration to lead this specific investigation. What is conspicuously missing is the name of a single assistant U.S. attorney who actually prosecuted Jeffrey Epstein or Ghislaine Maxwell. This absence is a critical detail for anyone trying to understand the internal dynamics of the Justice Department. Career prosecutors, the people who have spent years living with the evidence, interviewing witnesses, and building the case, are notably absent from the top-level disclosure efforts. Instead, the signatures belong to people chosen for their loyalty and their alignment with the political executive. It raises a profound question about the review process. Is the filtering of these 2 million documents being guided by legal precedent or by political strategy? The Justice Department defends this structure by pointing to the sheer scale of the task. They argue that a team of 400 lawyers is necessary to handle the volume and ensure that sensitive victim information is not wrongly disseminated. However, critics like Dave Ehrenberg point out that the administration specifically avoided involving career prosecutors who served under previous administrations. For example, Maureen Comey, who successfully prosecuted Ghislaine Maxwell, was notably unavailable for this process. Instead, the number 2 person at the DOJ, Todd Blanche, who was once a defense lawyer, was chosen for tasks as sensitive as interviewing Maxwell herself. This shift from career experts to political supervisors creates a bottleneck of influence. While the hundreds of lawyers on the review team might be doing the heavy lifting of reading pages, the ultimate decision on what is redacted and what is released rests with the supervisors at the top. From a neutral standpoint, this could be seen as a necessary measure for executive oversight in a high-profile case. But from the perspective of transparency advocates, it looks like a system designed to ensure that the chips only fall where the administration wants them to. The concern is not just about who is in the room, but who has been pushed out. When career prosecutors are sidelined, the institutional memory of the case is lost. These were the people who knew which names appeared in which ledgers and which flight logs mattered most. By replacing them with political appointees, the department has essentially reset the clock on the investigation, allowing the review process to become a permanent shield against the full disclosure of the Epstein network. The legal machinery grinding behind these redactions is as much a creation of Congress as it is a tool of the Department of Justice. While the Epstein Files Transparency Act was presented as a bipartisan victory for truth, a closer look at its architecture reveals it was built with a series of deliberate loopholes that allow the executive branch to control the flow of information. These gaps in the law provide the DOJ with the authority to withhold any document tied to an existing criminal investigation or those deemed to affect national security. In practice, this means that as long as the administration keeps a case file open in the Southern District of New York, they have a legal shield to keep the most sensitive Epstein records away from the public eye. Beyond the redaction categories, the most glaring flaw in this legislation is the total absence of an enforcement mechanism. There is no legal penalty for missing deadlines, and no independent body with the power to overrule the department's decisions in real time. Dave Ehrenberg points out that if Congress wanted to compel the production of these files, they would have to rely on inherent criminal contempt powers, a tool that has not been successfully used in nearly 100 years and would likely be struck down by the current Supreme Court. This leaves the DOJ in a position of absolute power, where they can slow-walk the process indefinitely without fearing any immediate consequences from the legislative branch. This lack of oversight creates the environment where the DOJ can essentially classify documents in their mind, deciding what is sensitive and what is safe for the public to see based on their own internal criteria. Because there is no summary or redaction list provided to explain why certain pages are entirely blacked out, while others are not, the public has no way of knowing if the department is protecting national security or protecting political allies. The process has become so haphazard that even the department's own lawyers struggle to maintain a consistent standard, leading to a system that feels more like a strategic information management campaign than a genuine pursuit of transparency. From a neutral perspective, the Department of Justice argues that these legal guardrails are necessary to prevent the release of child pornography or classified intelligence that could damage global alliances. They contend that the complexity of the 2 million documents requires a cautious, legalistic approach to avoid horrifying incidents for the victims. However, the result of this caution is a glacial pace that benefits those who would prefer the Epstein story to fade from the news cycle. By the time the remaining 99% of the files are eventually reviewed, the political and legal landscape may have shifted so much that the information no longer carries the same weight, effectively granting a de facto immunity to those mentioned in the files. The real danger of this legal gridlock is the erosion of trust in the very institutions meant to provide checks and balances. When a law meant to ensure transparency is used to facilitate secrecy, it sends a message that the system is unworkable. As long as the DOJ is allowed to operate without a transparent redaction logic and without the fear of congressional enforcement, the Epstein files will remain a symbol of how a superpower can use its own legal codes to bury the truth under a mountain of 2 million unread pages. The haphazard and scattershot nature of the redaction system is perhaps best illustrated by the striking inconsistencies in whose names and faces are allowed to reach the public. While the Justice Department claims to be following a rigorous set of rules, the actual output suggests a system influenced more by political optics than by a uniform legal standard. One of the most glaring examples of this bias is the treatment of former President Bill Clinton. Throughout the released files, Clinton's name and images appear unredacted and highly visible, including reports of him in a hot tub with an alleged victim. The department has made little effort to shield his identity, leading many to wonder why his information is treated as fair game, while other high-profile names remain entirely blacked out. From a neutral perspective, this could be seen as a fulfillment of the department's duty to the public, yet it stands in sharp contrast to how information regarding Donald Trump was handled. Initially, images of Trump with Jeffrey Epstein were posted to the public library, but they were quickly pulled down once the department realized he was in them. It was only after a significant public outcry that these images were restored, suggesting a level of sensitivity for the administration's leader that is not afforded to his political rivals. This inconsistency extends beyond political figures to the alleged co-conspirators themselves. The name of Leslie Wexner was revealed unredacted as a potential co-conspirator, while the names of nearly all other living alleged co-conspirators have been scrubbed from the record. There is no clear legal explanation for why some powerful associates are named while others are hidden, making the entire system of redactions appear arbitrary and politically ginned up. Perhaps the most troubling aspect of this bias is that while the DOJ is meticulous in protecting the names of accused co-conspirators, information belonging to the victims has slipped through the cracks. There have been multiple embarrassing incidents where sensitive victim information was posted, causing fresh trauma to the very people the department claims to be protecting. It creates a disturbing hierarchy where the privacy of the accused elite seems to take precedence over the dignity of the survivors. Ultimately, these patterns suggest that the 400 lawyers assigned to the task are looking for specific names that could cause political fallout. When photos are pulled down because they show the wrong person and redactions are applied unevenly across political party lines, the credibility of the entire investigation is called into question. It leaves the public with the impression that this transparency is actually a highly curated narrative, designed to manage a political crisis rather than deliver impartial justice. The true engine of any investigation is not just the laws on the books, but the human beings who hold the files. In the Epstein Files saga, we are witnessing a tactical replacement of institutional memory with political oversight. The dog that didn't bark is the complete absence of career prosecutors, the professionals who have spent decades inside the system, from the top-level disclosure efforts. Instead of the veteran attorneys who successfully built the case against Jeffrey Epstein and Epstein Maxwell, the signatures on these critical 5-page letters belong to high-level political figures like Jay Clayton, Pam Bondi, and Todd Blanche. This shift is exemplified by the removal of career experts like Maureen Comey, who was a lead prosecutor in the Maxwell case, but was notably fired and made unavailable for this review process. In her place, the department has elevated figures like Todd Blanche, the number 2 person at the Department of Justice. Interestingly, Blanche is a former defense lawyer who was tasked with interviewing Maxwell outside her prison, despite not being intimately familiar with the intricacies of the original case. For many legal observers, this looks less like a standard review and more like a carefully managed purge of independent voices. From a neutral perspective, every administration has the prerogative to appoint supervisors they believe will be loyal to their vision and policy goals. Proponents of this shift might argue that the Epstein case is so politically charged that it requires the steady hand of top-tier leadership to manage national security interests and victim privacy. They would point out that the team of 400 lawyers is still doing the fundamental work of reviewing documents, regardless of who sits at the top of the organizational chart. However, the loyalist takeover creates a unique bottleneck. While those hundreds of attorneys may be sifting through the 2 million pages, the ultimate decision on what the public sees is filtered through a small group of people who were appointed specifically because the president trusts them to have his back. This structure ensures that no career prosecutor from previous administrations can provide a dissenting view or push for the unredacted release of information that might be politically inconvenient. By sidelining those who knew where the bodies were buried in the case files, the Justice Department has essentially reset the clock on the Epstein investigation. Without the institutional memory of the original prosecutors, it becomes much easier for a review team to overlook key connections or deem certain incriminating documents as non-responsive to the act. This is how a massive investigation begins to vanish, not by burning the files, but by changing the people who are allowed to read them. The existence of the DOJ Epstein Library was supposed to be a monument to government transparency, a digital repository where the public could finally see the inner workings of a global scandal. Instead, it has become a digital graveyard where information is managed rather than shared. The sheer scale of what is being withheld is almost impossible to visualize without looking at the hard data provided by the department itself. When U.S. Attorney Jay Clayton admitted that they are sifting through more than 2 million potentially responsive documents, he was describing a mountain of evidence that could take decades to process at the current rate. If you were to stack 2 million pages of paper, it would stand over 600 feet tall, yet only a tiny fraction of that height has been cleared for public viewing. This backlog is not just a logistical hurdle, it is a strategic barrier. The Justice Department argues that the sheer volume of material requires an unprecedented commitment of resources, noting that hundreds of attorneys are dedicating their entire workdays to complying with the Transparency Act. They describe a workforce of over 400 lawyers and 100 specially trained FBI document analysts who are tasked with a fine-tooth comb review of every single page. From a neutral standpoint, this is a massive administrative burden for any government agency to bear. The complexity of handling sensitive victim information, grand jury records, and national security data means that every word must be weighed against federal law and privacy protections. However, the haphazard nature of the releases that have actually made it to the library suggests that even with 400 lawyers, the process lacks a clear and consistent logic. We have seen pages that are entirely blacked out from top to bottom, while others contain only surgical redactions of specific names. This inconsistency raises questions about the quality control checks the department claims to be performing. If the review is truly about protecting victims, it is difficult to explain why victim identities have been leaked while the names of powerful associates remain shielded. The department admits that despite their efforts, information that victims believed should have been redacted has been posted to the public site, forcing them to pull documents down and put the toothpaste back in the tube. The 2-million-page backlog effectively functions as a permanent stay of execution for the reputations of those mentioned in the files. By keeping 99% of the documents in various phases of review, the DOJ retains total control over the narrative. There is no public timeline for when the next 1% will be released, and as we have seen, there is no enforcement mechanism in the law to force their hand. For the public, the Epstein Library is not a source of answers, but a reminder of how much is still being hidden. It serves as a bureaucratic maze where the truth is not lost, but systematically filed away under the guise of an ongoing review that has no visible end in sight. The internal logic governing these redactions reveals a troubling hierarchy of protection that seems to prioritize the reputations of political figures over the privacy of the victims the Department of Justice claims to serve. While the department employs a massive team of over 400 lawyers to review every page, they have repeatedly allowed sensitive victim information to be posted unredacted, a mistake they characterize as an unfortunate side effect of the massive workload. These incidents have caused what legal experts call horrifying consequences for survivors, effectively re-victimizing them while the department attempts to put the toothpaste back in the tube after the names are already in the public domain. In stark contrast, the protection afforded to certain political elites and their associates appears much more rigorous and, at times, inconsistent. This is most visible in the scattershot treatment of names and images associated with the highest levels of power. For example, the name of Leslie Wexner was revealed unredacted as a potential co-conspirator, yet the identities of almost all other living alleged co-conspirators remain shielded by dense black redactions. There is no clear legal summary or redaction list provided to explain why one powerful individual is named, while dozens of others are kept in the shadows, leading to accusations that the process is being managed with a political finger on the scale. The treatment of former President Bill Clinton versus Donald Trump provides perhaps the most debated example of this redaction bias. Throughout the released files, Clinton's name and images, including a controversial report of him in a hot tub, are presented with little to no redaction. Meanwhile, the department's reaction to images of Donald Trump with Jeffrey Epstein has been markedly different. When such images were initially posted by accident, the DOJ was quick to pull them down, only restoring them after a significant public outcry. This disparity raises a critical question. Is the DOJ applying a single legal standard to all former presidents, or are the rules of transparency being rewritten based on who currently holds influence over the department's leadership? From a neutral perspective, the Justice Department might argue that these decisions are based on the specific legal status of each individual or the nature of ongoing investigations. They may contend that some figures, like Bill Clinton, are already so closely associated with the case in the public record that redaction would be moot, whereas others require protection to ensure a fair trial in potential future cases. However, without a transparent explanation for these choices, the public is left to view the redaction process as a tool for political warfare rather than a neutral exercise in justice. This hierarchy of protection ultimately undermines the credibility of the entire library. When the public sees victims being exposed while the elite remain protected, it reinforces the perception that the system is designed to manage the fallout for the powerful rather than provide a full accounting of the truth. As long as the redaction logic remains a black box controlled by political appointees, the released files will continue to be viewed through a lens of suspicion, suggesting that the most incriminating evidence is still hidden among the 99% of documents that have yet to see the light of day. The admission that 99% of the Epstein files remain hidden is not just a failure of bureaucracy, it is a final verdict on the state of institutional trust in America. When the Department of Justice admits to holding back 2 million pages of evidence while operating under a law meant to ensure transparency, they are essentially telling the public that the truth is a managed commodity. This systemic slow walking has transformed what was supposed to be a bipartisan search for justice into a masterclass in information control, where the law serves as a shield for the powerful rather than a sword for the victims. The consequences of this secrecy extend far beyond the Epstein case itself. Every time a political appointee is chosen over a career prosecutor to lead a sensitive review, the foundation of judicial independence is weakened. By sidelining the professionals who built the original case and replacing them with loyalists like Todd Blanche and Pam Bondi, the department has signaled that political loyalty is the primary qualification for handling the nation's most sensitive secrets. This creates a dangerous precedent where future administrations can simply review inconvenient truths until they are no longer relevant to the public consciousness. From a neutral perspective, the Department of Justice continues to maintain that their cautious approach is the only way to balance the public's right to know with the legal requirements of national security and privacy. They argue that the complexity of the 2 million documents makes any faster pace impossible, without risking the integrity of the legal system or the safety of those involved. However, as critics point out, as long as there is no enforcement mechanism and no transparency in the redaction process, the public has no way to verify these claims. The dog that didn't bark, the missing signatures of independent prosecutors, will always remain the most damning piece of evidence against the department's narrative. Ultimately, the future of justice in the Epstein saga depends on whether the public and the media continue to demand the remaining 99%. If the Department of Justice is allowed to finish this process behind closed doors, with a team of 400 lawyers answering only to political supervisors, the full story of the Epstein network may never be told. We are left with a system that has admitted its own failure, leaving a mountain of 2 million pages as a monument to what happens when transparency is treated as a threat rather than a duty. The true shock admission isn't just that the files are hidden, it's that the system was designed to keep them that way.